The question is, what evidence do the police need to prove that I'm using my mobile phone whilst driving? Well, there's no particular rule about what type of evidence the police need to have. The only rule is that they must have enough evidence to make a magistrate's court sure that the person is driving, that they're using a handheld mobile device in their hand whilst they're driving. Now, in many cases, that will just be the evidence of a police officer who sees what happened, and in most cases, that will be enough to persuade a magistrate's court that the offence has been committed. Having said that, there can be all types of other evidence that might make the case stronger. Now, there's no limit on what type of evidence can be used, but here are some examples of quite common pieces of evidence that the police use. So there could be CCTV footage, there could be dash cam from a police officer, there could be evidence from an eyewitness, mobile phone evidence from an eyewitness. Also, it's quite common to see cases where somebody's been caught on a speed camera, and that speed camera has also seen them on their mobile phone, and that would also be enough to prove a mobile phone offence. From time to time, the police might get data from the mobile phone to show that it's being used. That's quite unusual, but it's also possible to have that type of evidence. But in the majority of cases, it'll be eyewitness evidence from a police officer or from somebody else, which would be used to prove the case. Of course, that can be challenged in court. If the driver chooses to challenge the case, take it to court, they can have a trial and challenge the evidence, present their own evidence, and of course the rule still applies. If the court is sure, or we used to say if the case is proved beyond reasonable doubt, then the driver will be guilty of the offence.